And welcome back to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, Facebook.com/CRNTalk, talking all things legal, all things constitutional. Mr. Richard Nixon. And so, sir, we were talking about CO2. And a lot of people in government and on the left say, oh, the world is falling, CO2 is going to kill us all. We will be destroyed and destroy the earth as well due to the CO2. But Richard, you disagree.
Well, and that's why I brought up the subject. The reason it's important is because we've always had, in fact, President Reagan said one time, I think the worst 5 words in the English language is something like, I'm from the government and I'm here to help you.
Yeah.
That is really, really ridiculous. And this is what I see these people who are calling the rest of us deniers. These people literally want us to give up our freedom and our liberty. And of course, anybody that's read my book or knows anything about it knows that that's the overarching theme of my book, is to maintain our liberty and our freedom and to not concede it to the government. So the government, at least in their push to blame humans for causing global warming, their philosophy is, give us the power, we will fix it. And of course, we know from previous experience that the government never fixes a problem that they assume. Mm-hmm. So don't give up the freedom. Keep denying, because science, not politics, is the answer to global warming.
That's very, very well said. And if you want more of that information, make sure to check out Richard's fantastic book, America, An Illusion of Freedom, available on Amazon.com, BarnesandNoble.com, and as well as on iTunes, and also on his personal website, www.pres37th.wx.com/America, or just Google America, An Illusion of Freedom, and it'll be right there for you. Moving on, this is a pretty interesting case. It's coming out of our home state of California here. This is a case colloquially known as People versus Daleiden. That's People versus Daleiden. And this goes back a couple years to when an activist group of investigative journalists were investigating Planned Parenthood and their role in perhaps some unseemly behavior. They videotaped some Planned Parenthood branches, and now are being prosecuted under a law, a 2016 law, which was interesting. We'll go into this a little bit later, regarding videotaping healthcare workers. Richard, this case smacks of bias. And what happened recently with this case is the case has been placed on hold as a motion is cited before the California Supreme Court on whether or not issues of bias are pertinent to this adjudication. Richard, what are your thoughts on this case, and what are your thoughts about potential political bias going forward here?
Well, I find it's interesting because something that I've written again in my book and several letters that I've written, basically what you have here is some young people who basically misled Planned Parenthood, and they were allowed to come in and videotape some certain things more or less undercover, and did discover that these people, Planned Parenthood, did in fact violate state and federal law regarding the use of aborted tissues from the fetuses. So there's no question that these people, that is the Planned Parenthood, did in fact violate the law. However, these young people also violated the law by invading their privacy, if you will. And now the issue becomes whether or not we should go forward, because we're finding that apparently it's true that the nonprofit organization, or at least Becerra in this case, the Attorney General of California, has never prosecuted any of these people other than these people who are going against Planned Parenthood, and they claim that there's bias there in the prosecution because the nonprofit organization sponsored and hosted his primary election party, where he had to sign that read, "I stand with Planned Parenthood," and they somehow tie in Kamala Harris in this same thing, because she was also instrumental in asking for help from Planned Parenthood in terms of contributions.
Yeah, and this part of this case is the most damning, I think, in terms of bias. It's according to the motion that the defense filed before the California Supreme Court claiming bias. They have provided documentation showing Kamala Harris, former Attorney General and now presidential candidate, drafted legislation at the abortion provider's Planned Parenthood's instruction to change the state penal code to make secretly recorded and distributing communications with healthcare providers a crime. That legislation was signed into law September 2016 while Kamala Harris was still serving as California Attorney General, and charges subsequently were filed against the defendants Daleiden and Merritt in March 2017, 2 months after Becerra, that is the new Attorney General in California, succeeded Harris as Attorney General. So it sounds like Planned Parenthood came to Kamala Harris and said, hey, we have these investigative journalists that have videotaped us perhaps doing nefarious things. We want to put laws on the books that will prosecute these investigative journalists.
Yes. And again, as the attorneys for the anti-abortion people said basically that when we have a long history of undercover investigative journalism that's gone unprosecuted, and that this is the first time that that's being brought, exposing criminal conduct in the abortion industry, the dots connect very easily. In other words, they've used what they would call prosecutorial discretion to not go after people unless the people they're going after happen to be contributors to them.
And one thing that's very kind of ironic about this whole story is that the defendants are actually being cited for invasion of privacy. That's one of the main reasons and why this becomes a prosecutable offense. And the invasion for privacy comes out of the Griswold case, which we've talked about before on this high-quality broadcast. And so it's very, very ironic that these anti-abortion activist investigative journalists are being prosecuted under some predicates concerning the Griswold case, when in fact the Griswold case was used to really push through Roe versus Wade in 1973.
Absolutely. And of course the Griswold case had to do with birth control pills and whether or not they were properly prosecuted and whether or not they could deny it to a married couple. I think the case, of course, the facts of the case make it kind of ridiculous. But in that case, the Supreme Court went out on a limb and basically said there is a generalized right of privacy in the Constitution, and when put to the task of showing wherein it resided, could not find it. And in fact, the dissent mockingly, I'm not sure it was Scalia, but one of the dissents mockingly said, well, tell us where it is. You've mentioned the 3rd, 4th, 5th, 7th, 9th, and 14th Amendments, but you haven't told us where the right of privacy actually exists in the Constitution. Well, that didn't dissuade the majority. They found that such a thing exists. And sure enough, just recently, just after that, was Roe versus Wade, which basically built on the Griswold case. Namely, there's the right of privacy, and that includes the right to an abortion.
So what they did is, for the Griswold case, is that, and I outlined in the dissent that you referenced, is that they took parts of different amendments of the Bill of Rights and built what you like to call a Frankenstein of law.
Exactly.
And so that's very, very interesting. So we're going to be looking forward, we're looking towards this case in the future, providing updates as warranted. So you guys stick around. We have a lot more to talk about here in the Legal Lounge, CRN Digital Talk Radio, crntalk.com. Joined by Richard Nixon, of course, and any vets out there, any of you veterans out there that knew Richard. We love connecting vets here on CRN Digital Talk Radio. Anybody that served with Richard during his time of service in 1963, 1965, or knew him in country in Vietnam as a contractor, 68, give us a call here at the office, 818-818-6400. We'd love to get you guys in contact, maybe have a couple drinks, and also provide you with a free copy of Richard's book. Stick around, you guys. We'll be right back here in the Legal Lounge, CRN Digital Talk Radio, crntalk.com.
Were you scammed into signing a timeshare contract? And did you miss the part that said you have to pay for your great idea? Not only for the rest of your life, but when you're not here anymore, you get to pass this turkey onto your family for them to pay for the rest of their lives. Thanks, Dad. Don't burden your family down the road, and don't be stuck with expensive timeshare payments forever. Get out of your bad idea timeshare contract guaranteed, or pay nothing. Call Resort Release today and learn for free how their timeshare exit team can help you legally exit your timeshare contract. They've helped thousands of people, and they're A+ rated with a BBB. So if you feel scammed, get mad and get out of your expensive timeshare contract right now, guaranteed. Call NOW.
800-716-9903. 800-716-9903. 800-716-9903. That's 800-716-9903.
CRN listeners, when you come to Southern California, stop by a great restaurant, the Dresden Restaurant at 1760 North Vermont Avenue in Hollywood. Enjoy great entertainment, like the music of the legendary Marty and Elaine at the world-famous Dresden Restaurant. The Dresden was a location for the making of the movie Swingers. Now you can swing with stars Marty and Elaine. Plus, enjoy great food, too, like French onion soup, artichoke hearts, and many other great appetizers. Seafood, there's salmon, shrimp scampi, New Zealand orange roughy, halibut, Lake Superior whitefish, and specialties like veal, marsala, piccata, and parmigiana. Plus, we've got a great roast rack of lamb, chicken piccata, and cordon bleu, and pasta dishes, too. Steaks, filet, New York, Chateaubriand for two. Much more, too, including pork chops, prime rib of beef, and an incredibly extra large cut of prime rib. It's the Dresden Restaurant, open for lunch Monday through Saturday and dinner Monday through Sunday. Check us out at 1760 North Vermont Avenue or call 323-665-4294.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet. So make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
And we are back here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Richard Nixon live here, CRNTalk.com, Facebook.com/CRN Talk. So, Richard, friend of the show, and I say that humorously, Mr. Samarinsky, he has an interesting take regarding President 1 Donald J. Trump. Mr. Trump has just been through the crucible of its independent counsel special investigation, which exonerated him, according to a lot of legal experts and the president himself. But Mr. Samarinsky believes that, hey, we should indict him anyways.
Yes.
What's he thinking here? Where's he going? What's the story in here? And what's next for President Trump when it comes to his potential legal jeopardy?
Well, it's Mr. Samarinsky, Professor Samarinsky, is very clever because he doesn't really say, let's indict the president. He likes to pose it as simply an academic question. Can we indict a sitting president? And he says that the Department of Justice has for years had a policy that you could not. And he said, why are we persuaded by them? Who are they? Department of Justice. And he basically says that since the Constitution does grant immunity to legislators in certain contexts, for instance, when they're giving a speech before the House or the Senate, whatever they say is absolutely immune from prosecution. So, and they take advantage of that. They say a lot of false things because they know they can't be prosecuted. So his argument is, since there's nothing about immunity regarding the president in Article 2 of the Constitution, doesn't that mean that he is not immune from being indicted while he's a sitting president? And of course my position is no, there's a good reason for that. And one of the reasons is that the president is elected by the whole nation. And if the president is to be removed, then he should be, and I think the Founding Fathers intended, that he be removed again by the whole nation. That is impeachment. Impeachment requires the representatives to, with the majority vote, to charge him with certain misdemeanors, and it requires 2/3 of the Senate to convict. And again, that would require the whole country then to be involved in removal of this president, as opposed to an attorney general from, let's just say, a small state that has a political problem with Mr. Trump in this case, bringing an indictment while Mr. Trump is president. This would do nothing except weaken the president, and I think, again, The Founding Fathers never intended that to be the case.
I think you're right, Richard. Just based on my cursory knowledge of the Constitution, a knowledge that I've gained from you by doing this show, is that there is nothing in the Constitution saying that the president can be indicted or cannot be indicted, but they did put specific language into the Constitution regarding impeachment.
Yes.
And so I think implicitly, just logically thinking about that is the recourse to address any legal wrongdoings. And that's why they put the term high crimes and misdemeanors into the Constitution regarding impeachment.
And I agree with you, Mike. And the other thing is this, that if the Constitution by the founders lists a particular way that the president can be removed for misconduct, and under Chemerinsky's theory, that still allows him to be removed by being indicted while he's a sitting president, why wouldn't that render the more cumbersome, namely the impeachment process, redundant? Why would anyone bother to go through the impeachment process when they could simply get an attorney general who might be politically motivated, as I said, to simply bring an indictment against a sitting president and rid us of that president that simply?
Yeah, and that if he was indicted, I mean, de facto that would become the purview of the judicial branch.
Absolutely.
And when, like you said, Richard, it's the duty of the people to elect a president and to not elect a president.
Exactly.
And also to elect their legislatures, the people's representatives, to conduct an impeachment proceedings.
Yes, and again, like I said, I'm surprised that Professor Chemerinsky is still worried about, I mean, I'm stunned that there are still people out there, given the tremendously stellar performance of, he's probably the most effective president we've had in the last 50 years in terms of doing what he promised and doing things regarding the economy, putting more people back to work. Everything he's done has been positive in terms of the people. And yet, why would anyone even think of trying to remove him? I'm flabbergasted.
Also, Richard, I think it's shown now, too, with our friend of the show, Nancy Pelosi, and a lot of other high-ranking Democrats are poo-pooing the issue of impeachment because they know it's going to be extremely politically damaging to the Democratic Party as well, similar to how it damaged the Republican Party
yes.
with Bill Clinton. So,
but it's weakening. This idea of the wall, for instance, is we're starting to find more people on the left who are agreeing, not based upon security interests, but based upon humanity, that the wall must be built. And one of them is, and I forget his first name, his last name is Friedman. He's a very, very staunch left-wing anti-Trump person, but he went to the border, the southern border, and he said, we need a wall.
Very interesting. We'll be right back, you guys, here in the Legal Lounge. Richard Nixon Live, CRN Digital Talk Radio, CRNTalk.com. Stay with us.
The smartest way for you to get the lowest prices on your plane tickets, domestic or international, is to call SmartFares first or last, but you've got to call us before you book your plane tickets. Fly anywhere in the world, fly anywhere in the U.S., and SmartFares can save you up to 75% on your plane tickets. We have the lowest airline ticket prices on over 500 airlines, and you've got a great 12-hour free cancellation window. Plus, with our live agent help, you can always get fast help and fast answers. So on your next trip, maybe today, maybe tomorrow, how about right now? Pick up your phone and call SmartFares, plus save up to 75% on your plane reservation. So call right now. 800-915-2644. 800-915-2644. 800-915-2644. 800-915-2644.
Hi everyone, this is Fred Dreyer telling you about my favorite Italian restaurant. It's Angelo's and Vinci's in Fullerton, California. Angelo's and Vinci's has the best pasta, the best seafood, the best salad, spaghetti, lasagna, and the most incredible pizza. And the chicken is delicious. Marsala, piccata, cacciatore, parmigiana, and more. For desserts, try our spumoni or our tiramisu, my favorite, flown in fresh from Italy. and the cannolis and the zeppolis are out of this world. Open for lunch and dinner, and don't miss the Sunday champagne brunch, just $23.95. Are you kidding me? It's all up the road from Disneyland at 550 North Harbor Boulevard in Fullerton, California. Angelo's and Vinci's, like Michelangelo and Leonardo da Vinci. Call 714-879-4022 or visit us online at angeloandvinci's.com.
We are the debt destroyer. Any debt you have, credit card, tax, student loan debt. Call now to get our free report that tells you how to destroy your debt. It's a great resource. Plus, when you make this free call right now, we'll have a debt destroyer expert ready to help you. They can show you how they can help you destroy your debt and get your life back on track. Debt problems don't have to be overwhelming. You can live stress-free and debt-free. Credit cards, medical bills, IRS tax problems, even student loan debt. Learn about free programs offered by the credit card companies, hospitals, and even the government that can help you slash your debt. Call right now for free information, including our Debt Destroyer Guide, a $300 value, yours free. Call right now.
800-515-6348. 800-515-6348. That's 800-515-6348. The following ad contains shocking material. Listener discretion is advised. Is someone in your family playing a dangerous game of Russian roulette? Over 43,000 people die a year from drug overdose. 120 people a day. 5 people every hour. 1 person every 12 minutes. 88,000 people die every year from alcohol abuse. Over 240 people a day. 10 an hour. 1 person every 6 minutes. Somebody you know may be next. Learn how to help someone you love get away from the drugs, alcohol, and bad influences. With the FMLA, people can take a leave of absence from their job and still keep it. Call Quit Drugs 321 now at 800-378-3315, 800-378-3315, 800-378-3315. That's 800-378-3315.
We are back here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Joined by Richard Nixon, talking all things legal, all things constitutional. And this is, well, let's get to that one later. We often lament Congress on this show here, but an interesting act has been, a bill has been submitted to the Senate from Mike Lee. He's from the great state of Utah. And it's called the REINS Act, the R-E-I-N-S Act, and it stands for the Regulations from the Executive in Need of Scrutiny Act, aka the REINS Act, like I said. This is an interesting piece of legislation that puts down certain benchmarks where Congress would need to approve.
Yes.
Need to approve certain regulations so long as they fall within 3 different categories. Whether or not these particular regulations will have a financial impact on the U.S. economy of $100 million or more. That's number 1. Number 2, increase consumer prices. Or number 3, the most nebulous one, or have significant harmful effects on the economy. This is a piece of legislation that was first tried at the statewide level in Wisconsin, signed by Governor Scott Walker in 2017. Richard, we often bash Congress about inaction, but this is actually something that we kind of agree that that's the right thing to do.
Yes, well, Senator Reins, Senator Lee, thank you. And it's clever that he used the word R-E-I-N-S, that is reins that you'd use on a horse to slow it down. Basically, one of his pet peeves is the fact that Congress will pass a law, and then the people who enforce the law, of course, are the executive branch. And from when that one sentence law will spring forth 1,000 regulations in order to enforce that one act of Congress. And in fact, he did a photo shoot one time with papers stacked up on one side of his desk that were an inch high. They were Congress's laws for that year, 2015, I think. And then on the other corner of his table was maybe a stack 6 or 8 feet high. Those are the regulations that sprang from that 1 inch of congressional act. So anyway, what he's saying basically is oftentimes we're held down and prevented from acting fully freely because of the regulations that the executive branch produces based upon Congress's laws. And he's come up with a method by which these regulations would be revisited and either struck or allowed to proceed based upon how much money is being involved and so on. So I think it's a good thing to begin with.
This is an instance, and we often lament the fact that Congress has pretty much given their power away to the judicial branch for political goals. It prevents Congress, or it helps Congress people from not really having to express themselves on particular issues. But it seems to me like this is a step forward of Congress actually taking power back from the executive branch.
Yes, but now, Mike, we'll see how far it gets. As I said, Mr. Senator Lee, this is one of his pet peeves, and hopefully he's not alone in. But you see, there's a counter influence, and that's this, that you can't hold Congress accountable for something the executive branch did. And that's exactly why Congress allows pretty much free rein when it comes to the Supreme Court. Because again, when the Supreme Court makes a decision we don't like, who do we blame? The court.
Yeah.
Instead of blaming Congress for not reining in the court the same way it could rein in the executive branch.
And it's interesting to me that he's doing this now. Perhaps it's because the Republicans have control of the Senate. Because President Trump, I mean, love him or hate him, he's waged a one-man war against regulations,
yes,
eliminating regulations left and right.
He's been very successful, that's for sure. And again, if people are interested in why Congress can run roughshod, if you will, over the executive branch and over the judiciary, it's because that one branch, Congress, is supposed to be the voice of the people.
Yeah.
And so rather than letting the Supreme Court, which is currently 9 unelected individuals, or the executive branch, which is composed entirely of non-elected individuals, rather than letting those two entities control this country in terms of the laws we must follow, Congress was put in charge intentionally. Mm-hmm. But Congress fails to act in many instances.
One of the major criticisms a lot of people on the right had towards President Obama was his use of regulations for policy.
Yes.
And so the genesis of this bill goes all the way back to 2009, and now we're seeing it come forward to the forefront with Senator Lee, as well as 34 other members of the United States Senate. This legislation also being co-sponsored by Senator Rand Paul. And Rand Paul is very, very influential when it comes to the more libertarian wing of the party, because he sees what we've seen. We've seen that the legislative process, the legislative branch, has kind of been defanged
yes,
from different reasons. But this is very interesting. I think this is a good step forward.
Yes, and it seems to me that this is a good example of your crack staff really doing their job and sallying out all these different numbers. I think it's excellent.
Well, we do what we can, and we're going to be looking forward to this too. I mean, this is very interesting too, and I think this is going to have a lot of effect on small businesses, because regulation has definitely been hindrance and to a lot of small businesses. But one thing that we really need to look to is this third caveat on when Congress must approve the regulations. This third criteria saying that's quote unquote significant effects to the economy. That's pretty subjective.
Yes,
wouldn't you say?
it is, and it's going to take. Maybe intentionally, it's going to take judicial interpretation. Also, I should say this, too, that as many times as I grouse about the Supreme Court and its authority, I have to make this distinction. Certainly, we require judges, including the Supreme Court, to interpret and to adjudicate cases. My main objection, probably my only objection with the Supreme Court, is when it assumes authority that was not given to it, under the Constitution. So I think we have to make that clear.
Very, very interesting. We're looking forward to this moving forward. Up next, right after the break, this is the case that we've been waiting for all day. I love this case. Taylor versus the City of Saginaw, Michigan. This is an issue that affects anybody who's ever gotten a parking ticket, and I'm sure that's pretty much all of our listeners around the world and coast to coast. So stick around, you guys, in the Legal Lounge here on CRN Digital Talk Radio, crntalk.com. Stay with us.
Do you owe back taxes to the IRS?
I think I saw
the president
Washington
has
Post wrote
changed the
about
tax
it,
laws,
I think.
and now you may be able to pay the IRS less. If you owe $10,000 or more in back taxes, the tax doctor can help you pay the IRS as little as possible allowed by law. There are new tax laws for business owners, the self-employed, even W-2 workers. If you have a back tax problem or a few years of unfilled returns, new help to save you money is now here. Call right now to see how the new tax laws can help you. Plus, right now, we'll waive the consultation fee and give you a free tax savings report. Attention business owners, the self-employed, and W-2 workers. Make this free call to the tax doctor now and learn how to take advantage of the new tax laws that may help you pay the IRS less. 800-985-1610. 800-985-1610. 800-985-1610. That's 800-985-1610.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
And we are back. Richard Nixon live here in the Legal Lounge. So, I'm sure a lot of our listeners out there have come out to their car after a long day at work or at school or dinner with friends or family, and they see under their windshield wiper a white envelope. It's the harbinger of doom, saying that you have broken the law. You have parked where you shouldn't have parked, or parked for longer than you should have parked, and you owe us some money. But now, according to a Sixth Circuit ruling from Taylor versus City of Saginaw, the common practice of parking enforcement officers, we all know those people, who chalk a tire to see if a car has been moved, that violates the Fourth Amendment of the Constitution. Richard, this is a fascinating case.
Yes,
and
it is.
It has interesting implications moving forward with the whole system of parking enforcement. What do you think about this case? What do you think about the Fourth Amendment implications here? And also, why is even the Fourth Amendment being applied here to this particular case in the city of Saginaw, Michigan?
Well, okay, but as a preface before this, let me say that the Sixth Circuit is in Michigan. It doesn't necessarily apply to people here in California. We're in the Ninth. But, however, most judges will consider sister decisions like this. Not that they feel bound by it, but they'll go by the logic in a discussion. And if they're persuaded that, in fact, the Sixth Circuit is correct here, they'll adopt that. So it's wise, if you're going to get a ticket, if you're going to have to appear in court because you got a parking ticket, you might want to try this and cite this case, Taylor versus City of Saginaw. But in general, what happened here is basically they're citing the Fourth Amendment. Now, we all know, of course, that the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So basically, some people would argue that the Fourth Amendment doesn't even apply in this case because this relatively minor intrusion, that is putting a chalk mark on the tire of a car, is certainly not unreasonable, and therefore there was no violation of the Fourth Amendment.
Yes. Very, very interesting. This notes from the case saying that the city fails to carry its burden of establishing that the community caretaker exception applies to this instance. First, on the facts, the city fails to demonstrate how the search bears any relation to public safety. I think that's point one.
Yes.
Point two would be the automobile is the person's personal property, but yet it's on a public road. I'm having a hard time in my mind really parsing the logic on that.
Well, that's right. And again, what we said earlier was the Fourth Amendment generally, if we reread it briefly, the right of the people to be secure in their persons, houses, papers, and effects, suggests that what we're talking about is things within a person's house, their person, their papers and effects. It talks about being within those things as opposed to being on those things. For instance, we're not talking about an invasion into the car and its contents. Mm-hmm. We're talking about marking with something that is clearly removable, a harmless mark on the property of another. Again, I'm not sure that for a strict constructionist guy like myself, whether or not the Fourth Amendment would apply. Plus, I don't like to see the Constitution dragged into these relatively minor. This is not even a misdemeanor. It's probably an infraction in Michigan, and therefore does it even rise to what the Founding Fathers would have intended, to drag the Constitution into it to resolve it.
But I think, and we've talked about this previously, and one of the great lessons I've learned from doing this show, Richard, is that I think the reason why is because of our old friend, the incorporation doctrine.
Well, that's right. The Fourth Amendment applies to the states and, of course, the city of Saginaw, Michigan, because of the incorporation doctrine. That is to say, in particular date, I think it was 1963, the Supreme Court decided to apply the Fourth Amendment to the states. I can't find it. I think it's page 100 in my book. No, I was going to give you the date and the actual case. But in any event, we wouldn't have this problem if the Fourth Amendment didn't apply to the states. And further, we have another problem, and that is the so-called exclusionary rule. The exclusionary rule is basically part of a motion to suppress, to say that where the sheriff has blundered, you can't use the evidence against in this case, the defendant or the infraction individual. And whether or not the exclusionary rule was ever intended to apply to a non-criminal matter is also. In other words, what do we do now? What's the remedy if we conclude that, yes, this meter maid did violate the Fourth Amendment by marking that person's tire? What do we do now? Do we find them not guilty? Do we apply the exclusionary rule to that situation? I'm not sure.
Yeah, because these aren't necessarily crimes. I mean, these are considered infractions.
Absolutely.
And so it's interesting to see, what's moving forward, how the cities now, especially in Michigan, where the Sixth Circuit has their purview, whether or not they're going to be able to generate the kind of revenue they need, that they do, via these parking tickets. And so Allison Taylor is the name of the woman who brought this case, and just parenthetically, I have to. My hat's off to you, Allison Turner, for really bringing this forward, because I've had some parking tickets in my time, and there's nothing more annoying than having to pay those $68. Stick around, you guys. We're going to be right back right after the break, wrap things up, and this is going to be a first on this show. We might have nice things to say about the Ninth Circuit. It's going to be very, very interesting concerning a particular case, and Richard's going to have a hard time with this one because I think he agrees with the policy but not the process. So stick around, you guys. We'll be right back here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com.
Hey, get a good night's sleep with MyPillow. I've seen the ads for years, and now I've got MyPillow. I ordered one. I ordered two, and I've been sleeping on them. I'm a back and side sleeper, and when I tried MyPillow, my sleepless nights are gone. I used to wake up in the middle of the night. Not anymore. You don't have to adjust your pillow. MyPillow adjusts to the shape you need and want. You toss out those flat, worn-out pillows. You sleep really well all night long. 100% machine washable and dryable, made in the USA, a 10-year warranty, and you can get 4 MyPillows. That's right, 4 for half the price. You get 2 premium MyPillows, 2 Go Anywhere pillows, plus you get free shipping. You got nothing to lose. Try them out. They're guaranteed. Go to mypillow.com. Use the promo code WINNER. That's promo code WINNER, mypillow.com, promo code WINNER, or call the direct phone number, 800-513-3363, 800-513-3363, or go to mypillow.com, promo code WINNER.
Imagine this is your money and someone wants to take it from you. Who is it? The IRS. They want your money, and guess what? They can legally take it, all of it if they want. Remember, they sent you that letter that said, hey, you owe us a bunch of cash and we're going to take it from you. So what do? Fight back by letting our team of experts at the Tax Helpline work it out with the IRS so you can keep your money. And we're good at what we do. When you hire us, you get a team of guys on your side that know the IRS laws and will fight to save your money. So if you owe the IRS a ton of cash and you want to keep it, call right now and learn for free how we can help you put it back in your pocket.
800-932-1597. 800-932-1597. 800-932-1597. That's 800-932-1597.
What are you going to do with your old car? You can try selling it, you could junk it, or you could donate it to Heritage for the Blind. Your car will be towed away for free, and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats. It doesn't matter if your vehicle runs or not. It will be towed away for free, and you'll be supporting those that need help. Heritage for the Blind is a nonprofit organization that helps the visually impaired live fuller lives. Call right now to donate your car, and as a special thank you for calling, you'll receive a free 3-day vacation voucher to many exciting locations. Call Heritage for the Blind right now, 1-800-785-9618. Donating is easy, and your vehicle is towed away for free. Plus, you'll get a free vacation voucher. Call now, 1-800-785-9618. That's 1-800-785-9618.
And we are back. Richard Nixon live here, CRN Digital Talk Radio, CRNTalk.com. We're in the legal lounge here on CRNTalk.com. So our friends over at the Ninth Circuit, this is a tough one. This is in regards to Donald Trump's policy on sanctuary cities. And our friend Becerra, once again, he is, the Ninth Circuit is saying that the federal government does not have a right. Just give us a little background here, Richard. I'm a little bit tongue-tied on this one. It's
okay.
This is a Ninth Circuit ruling regarding the sanctuary cities policy of the president.
Yes. Well, briefly, it says that the Ninth Circuit Court of Appeals largely affirmed Thursday a federal judge's decision not to grant the Trump administration an injunction blocking the enforcement of 3 California laws aimed at disassociating the state from the president's crackdown on illegal immigration. The president is basically saying, under the Supremacy Clause, the Article 6 of the Supremacy Clause, which basically says that the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So, under Article 6, if a particular subject matter is deemed part of the federal government's authority, it is in charge. And this is how the president looks at the Article 1, Section 8 that deals with immigration. The president claims that since immigration is strictly a federal function, it's totally in charge. On the other hand, Mr. Becerra and other people that represent states claim under the 10th Amendment that the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or the people. Now, quite frankly, my general inclination is to fall toward the 10th Amendment because I believe that the federal government asserts power that the Constitution never gave it. And this is an interesting case between two competing behemoths, if you will, the Supremacy Clause of the Article 6 and the 10th Amendment. I seem to come down this side with the Ninth Circuit. I think I think the 10th Amendment prevails.
Oh, mark it down. Mr. Richard Nixon is agreeing with the Ninth Circuit. This is a red banner day for the courts.
But I reserve the power to amend my decision later.
Recognized.
But again, because so many of the things that the court talks about is that the federal government was, in a sense, demanding or commanding allegiance by the states as opposed to asking it to voluntarily cooperate. And of course, we know what the position is in Becerra. He's giving no quarter at all. They believe in their sanctuary cities, and they believe that the federal government is up to no good to try to rid them of some of these people many of them who could be here illegally.
Well, there you have it. Mr. Richard Nixon, a man of principle. Even though he agrees with the president's policies, he also, from his strict constructionist background, sees the need and the rights of the framers for states' rights. And so there you have it, you folks. We're going to look forward to that. We've run out of time. Thank you so much for joining us here in the Legal Lounge. Richard Nixon Live. Make sure to check out his book, America, An Illusion of Freedom, available wherever fine books are sold. All previous episodes are available on YouTube and also on podcast. Visit Richard Nixon, visit SearandTalk.com/podcaster for all those. Richard, until next week, thank you very much.
Thank you very much.
All right, and see you. Thank you so much to all of our listeners, all of our Facebook viewers around the world. And we'll be back next week with more Legal Lounge, Sear and Digital Talk Radio, SearandTalk.com, Facebook.com/SearandTalk. See you next week.